Hasbrook Heights, Hackensack. Yes. Well, we'll do will and potentially, yeah. Well, you have two options. You can do it online and save a lot of money. Depends on the level of your assets and so forth. And if you want a lawyer, then we can help. Yes, absolutely. You got to resolve it. 100%. Absolutely. Yes. That's for sure. الموت حق. My name is Abid. Yep. It's Abdul Aziz, but by short they call me Abid. In Hasbrook Heights, Hackensack. Yeah, on Route 17. Oh, so you know the area well. Yeah. Inshallah. Yep. Inshallah. Alaykum assalam. Yes. 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 So in that particular case, what we have to do is what's called, we got to create a special needs trust. So if she's... What? Sure. Well, we're going to have to do something in your life.
Assalamu alaikum.
That's a complex
Inshallah, we'll get started now. Bi'idhnillah. We'll have a Q&A section in the end. Okay, inshallah. But we have to be quick because we have an event. We're starting, inshallah. Okay.
But this one needs planning. Very powerful. She has a major. Yeah. 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 Yes. Okay. Other than the house, do you have anything else? So, go to Sharia with and try, because it's only $200 more a will. We charge $15. So I ask if it's not too complicated, you can do it yourself. And if you have any questions, call us. Not a good idea from a tax perspective. So I'm going to talk about that when we're here.
Okay, inshallah, we'll get started. You want to use this one, inshallah? Yeah, it would be... other way, I think. Yeah. For all the kids, please take a seat next to your parents. We're getting started now, inshallah. Jazakumullah khair.
يلا السلام عليكم والصلاة والسلام على سيدنا محمد وآل سيدنا محمد. First, I want to take this opportunity to thank the organizers of the mosque for inviting me here. I went to St. Peter's College in Jersey City, and I used to live in Bayonne. I live in Wayne. I haven't been back to Bayonne in a long time. This is not the Bayonne that I remember. I graduated from St. Peter's in 1991, and there was nothing like this. So I'm very happy to see my community growing and to see that a beautiful mosque in the heart of Bayonne is thriving. So we're here tonight. I'm an estate planning lawyer. I've been a lawyer for 25 years. I practiced in the state of New York and the state of New Jersey. I taught Islamic law for 17 years at Rutgers Law School. Currently, my practice is exclusively related to estate planning, especially for faith-based estate planning relating to Muslims. So I'm going to give you an overview of the Islamic law of inheritance, its interplay with New Jersey law, and provide you with an opportunity to ask questions, because I do these all over the country. And I find that the most productive webinars or workshops is me engaging with the audience and answering any question. There is no question that is stupid. You ask anything you want and I will explain it. I'm also the CEO and founder of ShariaWiz.com, and I have some flyers that I can give you. ShariaWiz is an award-winning Islamic estate planning platform that I created after 25 years of practicing law. People come to me, they have to pay anywhere from $1,500 for an estate planning will, or almost $4,000, $5,000, and sometimes $10,000 to do a trust. So what I said is that so many Muslims, a lot of the families are middle class, don't have a complex estate. If you don't have disabled children, if you don't have divorced and you have a second wife, and if you don't have the complexities, this could be sufficient and save you money. So you can go to ShariaWiz.com and create an Islamic will, a power of attorney, a healthcare directive, a HIPAA form, all online for $200, $199. If you want a trust, individual trust is $499, and a waqf ahli. We also created cutting-edge waqf ahli structure to keep wife and husband's property together, and there's no distribution until the surviving spouse passes away, and that's $799. So that is for many people who are somewhat educated or have kids can help them. You can save money. But if you still want a lawyer, I'm available. And I can handle your estate, I can handle your will, I can customize and do what you wish. So let me just give you the overview. The Islamic law of inheritance is a mandatory intestacy inheritance system. What that means is that when a Muslim passes away, you have only control of up to 1/3 of your estate for non-heirs, but the rest of your estate has to be distributed according to the Sharia. And in the Quran, it specifically says in Surah An-Nisa, this is an apportionment from God. In truth, God is all-knowing. So there is not much room and flexibility outside of our inheritance, because the divine directive is that an estate is going to devolve and be distributed at a person's death. So the Sharia rules of Islamic inheritance is divided into 3 levels of beneficiaries, 3 categories. The first one is called Ahl al-Fara'id, the Quranic heirs. And Ahl al-Fara'id is basically in Surah An-Nisa, there is specifically mention of predetermined shares. So the Quran either says half, quarter, 1/8, 2/3, 1/3, 1/6. These are the shares that are specifically included in Surah An-Nisa, and it's 2 categories, male and female, of course. 9 females, wife, daughter, son's daughter, mother, paternal grandmother, maternal grandmother, full sister, maternal sister, and paternal sister. These are specifically called Ahl al-Fara'id because the Quran has a particular percentage for one of these, each one of these people. Then there's 4 males, husband, maternal brother, father, and paternal grandfather. So as you can see, the moral worldview of the Quran and of the message and the mission of the Prophet Muhammad sallallahu alaihi wasallam was very woman forward. It was driven to protect Muslim women, to create gender equity and protect women in our society. So you see 9 of the required prescriptions in the Quran are for women. Only 4 are men: the husband, the maternal brother, father, and paternal grandfather. Then the second category is what's called the residuary heirs. The residuary heirs who are taking the balance, taken by ta'sib. Bil Arabi, it's called ta'sib. And ta'sib means that after the folks with those half, quarter, eighth, once they take their prescribed shares, if anything is left, it's going to go by ta'sib. And ta'sib is going to basically go to a rank in priority in the paternal line. For example, a son and a daughter, they take any balance remaining after the prescribed shares. So in a situation where somebody passes away, he has a mother, a father, a daughter, and a son. Mother takes 1/6, father takes 1/6, and the 2/3 are going to be divided between son and daughter, مثل حظ الذكر أنثيين. So double the share of the male of his sister. So they take by ta'sib and take the balance. Let's say if there were no children. If there were no children, the siblings will take by ta'sib. If there are no siblings, the nephews will take by ta'sib, and so forth. The third category is Dhul Arham. And Dhul Arham is a very rare circumstances, especially for Muslims, because we are extended families. It would mean that there are nobody in the prescribed share, no mother, no father, no grandmother, no grandfather, no nephew, no fifth cousin. You have no family in the paternal line. Then the Quran talks about Dhul Arham, which is most commonly defined as distant kindred or outer family. So this goes through the maternal line as opposed to going through the paternal line. So the Sharia on the Islamic rule of inheritance, just FYI, algebra was created because of the Islamic rules of inheritance, because the Muslim scholars had these complex family scenarios that you needed to create mathematical formulas to figure out. And that's where algebra was born. And the Prophet Muhammad sallallahu alaihi wasallam said, "Nisf al-ilm, ilm al-fara'id." Half of the science and knowledge is the rules of inheritance. So they created a concept called the rad. And when the total prescribed shares do not exhaust the entire state, the balance left will be distributed according, as we said, the doctrine of ta'sib or rad, meaning that you would increase the shares. So if we have a situation where you have the prescriptions, but it did not exhaust the estate, so you still have like 10%. That 10% will go to ta'sib, to the paternal line. If there is no paternal line, it may return by apportionment to all of the folks that already inherited. And that's called rad. Ta'sib we already explained. This is the basic framework of the Islamic rule of inheritance. This is, your idiot's guide to the Islamic rules of inheritance. It's very brief, but it really explains to you how the Sharia really framed the way an estate is to be distributed. Now, because of technology, we were able to take all these complexities. I spent 3 years developing Sharia Wiz, and we created the most advanced, award-winning Islamic inheritance calculator. And it's free to the public. You can go to shariawiz.com and you answer your family tree, no matter how complex, and it will determine what are the percentages and what are the shares for all of your beneficiaries with the Sharia explanation and the Quranic verse or hadith that supports that conclusion. So you should try it and see how technology is helping our community to have more accurate distributions, because in the past, when you have complex scenarios, you got to go to the imam, and the imam's going to spend hours of research trying to figure it out. We have been able to automate it and create this calculator. So in New Jersey, you have two roads to organize your affairs. So, al-mawtu haqq, we're all gonna die. If you die without a will in New Jersey, if you're married and you have children only from your current wife, your wife gets 100% of your estate. Your parents don't inherit, your children don't inherit. If you're married and you're divorced and you have children from different spouses, the wife will get 50% and the children will get 50%. So ultimately, the scholars around the United States have taken the position that having an Islamic will is actually fard. Because in Pakistan, in Palestine, in Egypt, in the Muslim world, when you pass away, by operation of law, Islamic rules of inheritance are applied. There's no opting out. So in the United States, as a secular civil country, unless you opt to be governed by the rules of the Sharia, you're going to be applying the non-Islamic rules to the distribution of your estate. So it is really a fard to do it. Now, you have two options. You have an option of doing a will, and you have an option of doing a trust. A will is basically a disposition at death, meaning that you prepare your will. It'll be Sharia compliant. When I pass away, here's who my executor is going to be. Here's the guardians of my children. And when I pass, if these are my heirs, these are the percentage they're going to receive according to the Quran. That's very simple, but that is enforced when you pass away. So your personal representative, your executor, will have to go to Jersey City, to the surrogate court, and take the will and probate that will, register it with the court. When you do that, when a person dies, all of his assets are frozen. You can't get access to his bank accounts, you can't sell anything. All of the assets are frozen until a court order appoints who the executor is. And there's going to be an oversight of the distribution by the court. And you have to prove that will in the court. And all wills are public record. So I can go to the court and I can pull people's wills and see what they said or what they did. The administration, like I said, has court oversight. There's more likelihood of disputes and fighting on the legal requirements. And probate is time-consuming and is expensive. Some states, like New Jersey, are not as bad. Like in California, the probate process is so complicated and so expensive, almost everybody who owns a home in California has a trust. Now, a trust is an agreement that you make in your life to create a legal entity, even though it's not like a corporate, it's like a corporation or LLC, but it's a legal agreement between you as the grantor and this trust that you're going to transfer all your assets into the trust in your lifetime. So that means that your wishes are implemented in your lifetime. So you will create the trust, you would transfer your assets in the trust, and you will say, when I pass away, this is the way the distribution is going to take place. Because you're doing it in your lifetime, there's no court. So when you pass away, you avoid probate, you avoid going to court, and your family affairs are private because it's not a public document. The successor will take over immediately. There's no freezing of accounts. You have access to everything. Nothing will change. Everything will be smooth. That's why most of the time we recommend to our clients to do a trust. But sometimes a will may be sufficient for most people, but always consider a trust. And like I said, we can do it for you at our office, and you can also do it online at a very competitive fee. One just academic idea, comment, the concept of a trust originates from Muslims. So in the Western world, there are two schools of jurisprudence. There's what we call the common law, the Anglo-Saxon law, which is the law of England, the law of America and Australia, their British system, which is the common law. And then you got the French, the Germans, the Swiss, which is called civil law. In the civil law system, there's no concept of trust. In the common law system, there's a concept of trust. Very prominent scholar, his name is John Maqdisi, did a research and wrote this article called The Islamic Origins of the Common Law. How did the British have a trust in their legal system where the French didn't? So he traced when the trust came into the common law, which was sometime in the 10th, 11th century, because the Normandies had come to Sicily and occupied Sicily from the Muslims. And when they occupied Sicily from the Muslims, it was a very well-developed, Siqilia in the Muslim tradition was pretty well developed. It was at the time of the height of Muslim civilization. So they had the diwan, they had administrative infrastructure. So the British didn't, they weren't British at that time, the Normandies, they learned from that administrative system and not destroy it. So the trust entered into the British, the Anglo-Saxon. And what's the trust in Arabic? Al-Waqf. So the concept of the trust originates from the Al-Waqf al-Islami. Now, Al-Waqf al-Islami, for most of us, we always hear about Al-Waqf al-Khayri, the public waqf, the public charity, that we create a waqf for this mosque and we save money so that it would run it. We dedicate some property investments, and the interest that comes from that and the benefit and the profit will be distributed to charity. So that's Al-Waqf al-Khayri. But also Muslim scholars created what's called Al-Waqf al-Ahli. And Al-Waqf al-Ahli, which is a family waqf, is not for public charity, it's a waqf for your family. So you can dedicate your assets in a waqf ahli for your children, your children's children, and it can become like a dynasty trust. And you can decide at a particular time there will be a termination, and there could be a distribution of the corpus assets, or you could say that at the termination it would be distributed to charity. So this waqf ahli, which is a very sophisticated system that Muslims use for 1,000 years, I have developed a waqf ahli that is compliant with the Sharia and compliant with New Jersey law. And now we are able to use this for our clients in New Jersey. So how does the waqf ahli work? It doesn't work for everybody because everybody has their own sensibilities. In waqf al-ahli, we do mainly for professional couples that own a home, maybe they own a business. We create a joint trust. And in the joint trust, the parties transfer all of their assets into the waqf. Now what happens is that we create two schedules. A schedule of assets for husband, schedule of assets for wife. The husband and wife can be 50-50 in everything, 80-20, whatever it is that you agree and whatever the law is as it pertains to the title ownership. When one party passes away, there's no distribution. So I always say husband's gonna die first because he's got most of the stress, so he's gotta exit first. He's in a hurry to meet Allah. So now when the husband passes away, there is no distribution of his schedule. The schedule remains in the trust, and it remains in the waqf, and the benefit and access and management to the surviving spouse. So now we did not dissolve the businesses. So I was speaking to somebody, like many people that I know, maybe they own 3-4 real estate properties and they're rentals, or they have a business, or they have certain assets and the kids are minors. What are you going to do with a distribution? You're going to break up the family business. You're going to break up the uniformity of the assets that were acquired during the marriage. So here what we do is we're able to preserve it until the death of the surviving spouse. So there's no distribution until the second spouse passes away. And then when there's a distribution, there's two schedules. That schedule of the husband is going to be distributed to the husband's heirs, and then there's a schedule for the wife that will be distributed to the wife's heirs, depending at the time of their demise and their passing away. So this waqf ahli has become a very popular structure that we do for many of our Muslim American clients. Also, we live in America. Islam, the way that I view the Sharia is basically what we would call a methodology or an epistemology that produces knowledge. Manhajiyya tuntij ma'rif. It's really a scholarly methodology. So the outcome of this methodology is what we call fiqh, which we call what the law is. But that law is very diverse. The fuqaha used to say, how do you define fiqh? Ilm al-ikhtilaf, the science of difference. Because the fiqh is not certain. It's depending on the unique circumstances of the case or legal issue that is raised to the mufti and to the scholar. So we used this methodology in my office and in my research over almost 30 years of studying the Sharia and working in this particular space. And there are many solutions in the Sharia that are very favorable and fair to spouses and work very well in the American setting. So for example, the Sharia allows what's called a life estate, haqq al-manfa'a, during lifetime. So some of my clients would say, okay, I'm going to pass away. I don't want my wife to be in the street. I don't want her to leave the house. So we can give the wife or the husband a life estate in the property before distribution. So haqq al-manfa'a, to live and occupy the house during her life. And when she passes away, there's a distribution. So that's Sharia compliant and solves and resolves many problems. Increase the mahr. The mahr is considered a debt against the estate. Mu'akhar al-sadaq is dayn. So if you, during your marriage, you got married in Egypt in 1982, and your mahr was 1,000 Egyptian pounds, like $10. Maybe now you're a physician and you're doing extremely well. You say, you know what? My spouse has invested 20 years building the family, left her career, working to us save all of this money. I'm going, in my lifetime, voluntarily, tu'an, bidun ikrah, without coercion, to adjust my mahr to be the marital residence, or $100,000. So now at death, she receives $100,000 plus her inheritance of 1/8 because of the debt. The same can take place also. There's a concept in al-fiqh al-maliki specifically called al-kad wa si'aya. Al-kad wa si'aya means effort and work. And this originates from what we call, how we describe al-Faruq, our Amir al-Mu'mineen, Umar ibn al-Khattab. So during Umar al-Khattab's time, there was a very famous dressmaker. And this dressmaker was married, had no children. She worked all night making the dresses. Gives it to her husband, he goes to the souk and he sells them. And he made a lot of money doing that. He passed away. Strictly speaking, according to the Qur'an's Surah An-Nisa, she will get a quarter because there were no children, and her husband will get 3/4 of the estate. So this woman went to Amir al-Mu'mineen and said, Amir al-Mu'mineen, you know who I am. I work all night doing all of this work. And his family, the paternal family, said they want to only give me a quarter. So he said, well, half of it is already yours because you contributed to the acquisition of the marital estate. So he literally flipped the formula, gave her the half and gave her a quarter of the estate. So the Malikis took this particular tradition and created this concept of al-kad wa si'aya. So we offer our clients, whether they come to our office or online, if they feel that their wife has worked and contributed to the acquisition of the marital estate, contributed money, left her career, you could acknowledge that certain percentage of the assets or an amount of money goes to her contributions during the duration of the marriage, plus she'll receive her 1/8 or 1/4 from her inheritance. And another solution, all of this is in our tradition. The problem is that we need to dig deeper in our tradition and look at this epistemology and this methodology to make things work according to the spirit of the Quran. The Quran is equitable. العدل والإنصاف هو قلب القرآن. So it's impossible that the Quran would say something that's going to lead to an injustice. Not possible. Therefore, we got to dig deeper to better understand the framework of how the Quran is organized. Another one is according to the Muslim marriage contract. According to the Muslim marriage contract, there are scholars that say that you as a husband are required to provide food, shelter, clothing. And some say a domestic servant to help around the house. Some say that if the wife originates from a high socioeconomic status and was accustomed to a servant, that you need to produce that servant. Some say, doesn't matter, you can produce that servant. So many people can take the position that the wife's contributions, cooking, cleaning, dealing with all of this during the marriage, even though she voluntarily did it for free and made it as a donation, you as a husband can simply acknowledge that I want to acknowledge all of those contributions. I should have compensated my spouse for those services. Now I'm going to acknowledge this debt in my will. I'm going to acknowledge this debt in my trust. I owe her for this. So she will receive the payment of that debt plus whatever her insurance is. What happened? It's okay because, listen, in Khutbatul Wada', Sayyidina Muhammad, all he talked about was about protecting women. الإشكالية إنه men are not standing up with their responsibilities under the Quranic requirements. I do prenups in my practice. I've been doing prenuptial agreements for 25 years. Generally, I get Muslim clients, they say, oh, we want a prenup, I don't want her to get this, she doesn't want to get this. But they always don't want to acknowledge their responsibilities under the Sharia. So I do Sharia compliant prenups. So good, you want to protect all your assets. Acknowledge your responsibilities towards the spouse. You have to provide food, shelter, and clothing. And if she works, you got to make sure it's not her money that's used. And you got to acknowledge there's something called, mu'akhar sadaq that you have to add in there. You can also do what's called nafaqat al-mut'a. And nafaqat al-mut'a is codified بقانون الأحوال الشخصية المصري والإماراتي والقطري, not in Pakistan. And nafaqat al-mut'a means that you are to compensate her out of your good heart for additional funds because of the marriage and the time, that companionship that you spent with her. What has happened is they codified it to be like 3 years of maintenance. But this is still open for discussion. So in my framework of an Islamic prenuptial agreement, we place the financial burdens on the husband because that, if you want gender-specific obligations, then comply with those rules. And the Sharia has that framework. In our Islamic wills, at my practice, or if you do it on Sharia wills, we always include debts and bequests. We talk about huquq Allah. If there is anything, you acknowledge it in your will. If you want hajj badal, or you want somebody to cover your hajj if you're not able to, we include that in your will. If you want to make sure that your zakat is paid off, we include that also in the debt section. Some have kaffarat. We include kaffarat if there is any. And if there are any nizrs or vows, we also include that in your will. Now, the amazing tradition that we have is encouraging us to leave a legacy, to leave charity. So the Sharia in the Quran allows up to 1/3 of your estate you can utilize for charity and helping your family. Anybody who is not a taker. So from a Sunni perspective, we have la wasiyya li warith. But in the Ja'fari perspective, there is wasiyya li warith. So Ja'faris can use that 1/3 to give more to their spouse, to their daughter, or what have you. But for Sunnis, you cannot give that 1/3 to anyone who is taking under your will, who's an Islamic heir. So for example, I have a son and I have a daughter. I can't give 1/3 extra to my son or to my daughter. But I can give 1/3 to my brother. But if I had only a daughter, my brother is an Islamic heir, so I can't give him 1/3. So it can't be somebody who is going to take. So this 1/3 is very important to build our institutions, to do a sadaqah jariyah, to help our community. The Muslim community's understanding of charity is you give fi sabilillah. It's very, very God-centric, Allah-centric, the way we look at charity. And it's because of that we've built one of the greatest civilizations in humanity. Do you understand or realize that in Turkey, almost 70% of the arable land was in a waqf? Do you know that one of the oldest operating hospitals in the world was a hospital in Egypt that continued for 600 years before it was destroyed in the 1950s? So our conception of waqf, Algeria, 70% of the land was in a waqf. In Palestine and in Syria and in Egypt, any of the major cities you would find in Jerusalem, most of it is waqf property. And these are individual waqfs that were created by Muslims. More importantly, women were leading in building waqfs. In Aleppo, reviewing court records, they found that almost 40% of waqfs that were created by Muslim women. So this aspect of our charity is what's going to transform our community in this country to have economic depth and political depth. Without dedicating and having charity and a legacy left behind, we're going to continue to be a weak community. So we have to build institutions. How are we going to build them? We only build them with remembering our mosque, remembering our institutions, remembering our organizations in our wills, because that's what's going to sustain them. Every university in this country, the majority of the money they receive is from legacy giving. The vast majority of every major not-for-profit in this country is sustained by people giving them money in their trust or in their will. So we got to wake up and smell the coffee. We started this tradition. This tradition is innate and second nature to us. So I'm hoping out of this conversation that I can make you aware that it's a religious obligation to remember. الَّذِينَ فِي أَمْوَالِهِمْ حَقٌّ مَعْلُومٌ. It's not our money. It's money we have to give out. And we need to be strategic about how we do it. So I'm going to conclude with just giving you an idea of what an estate plan is. We talk not Islamic will or Islamic trust. We say Islamic will-based estate plan or Islamic trust-based estate plan. So an Islamic will-based estate plan, we create an Islamic will, we create a power of attorney, because let's say you got disabled or you got hurt. Who's going to handle your financial affairs? So we do a will, a power of attorney. Also, what happens if you're in the hospital? Who's going to make the decisions on your medical care? Do you want to be on DNR? Do you want to be resuscitated? Do you want, if you're brain dead, to remove all artificial assistance? All of those are addressed in these 3 documents. So we cover you in the event of death, in the event of incapacity, in the event of you being in the hospital. So that's the will-based estate plan. A trust-based estate plan, we do a trust, an Islamic will, a power of attorney, a healthcare directive. So it includes 4 documents. All of these documents we draft them as lawyers if you hire us, and they're available also online. So when you create your will-based estate plan on shariawiz.com, it creates all these documents. And it takes you 15 minutes to create your Islamic will and about 30 minutes to 45 minutes to create an Islamic trust. So with that, I'm going to open this up for discussion. And let me know any question you have regarding to estate planning, Islam, American politics, whatever you want. I'm here to talk. Thank you.
For taxes, which Which one, either will or trust?
There are no tax advantages from a will or a trust. The tax advantages come in for people who have $24 million and up. So if you're married, each person has $13 million that is deductible and exempt of estate taxes. There's a federal estate tax in the United States that charges you 40% estate tax on anything over 13 million, or if you're married, anything over 26 million. If you live in New York, there's also a state estate tax. New York grabs you at 6 million. So if you have any assets over 6, you're going to pay an estate tax. Now, from a tax perspective, what's important is doing the will and the trust is you're leaving your house and your property to your heirs at the time of your death. So they get what's called step-up basis. Right now, I had one of the attendees here ask me, oh, I want to transfer my house and put it in my kid's name. What do you think? Well, if I give them my children my home right now, whatever is the fair market value of my home, they get the cost I paid for it when I bought it. So if I bought my home for $300,000 and my home is worth $800,000 right now, if I give the house to my son, he's taking it at the $300,000. So when he ends up selling it, he's going to pay taxes on $500,000. But if I give him the house when I kick the bucket, he gets it at the fair market value when I died, which is $800,000, so he doesn't pay taxes. So we have to be careful. A lot of us in the community, we transfer homes and put it in the kids, hoping to avoid creditors and being safe, but that also can open up a taxable issue.
السلام عليكم.
وعليكم السلام.
شكرا شيخ. It's very instructive. ربي يبارك فيك.
من كاسا ولا من
من مين؟
انت من المغرب؟
من الجزائر.
من الجزائر.
شكرا.
Yeah.
استغفر الله. Yeah, anyway, I did already a will in a very simplistic way. Just download some documents and I notarize it. I have 2 witnesses. And I did, of course, mention that everything should be done according to the Sharia. Is it enough or?
No, it's not enough. You have to go do it, save yourself. If you sound sophisticated, go on Sharia Wiz and redo it. Because what happens is that we live in the United States, we're a secular country. If you take a will to the court and say, apply Islamic law, the judge has no authority under American law to apply or enforce Islamic law, because that violates our First Amendment separation of state and church. So on that perspective, that's problematic and may not be enforceable. But the way we draft the wills is we draft the wills explaining Islamic law in detail so that the judge is not interpreting. The judge is just simply applying what's in the will. So in our wills, it's going to say, at the time I signed this will, I am married, and I have a son, and I have a daughter, and I have a mother, and I have a father. So if I die, and these are my heirs, 1/6, 1/6, 1/8, and the balance goes to my children. But if I die at the time of my death, my heirs changed, my family tree changed, I am authorizing my executor exclusively to redo the calculations according to the Islamic law inheritance appendix attached to my will. So in that case, no judge's interpretation. That makes it enforceable in a court of law. And when we do a trust, it doesn't go to court anyways. So I think you need to update it, and it's very simple. You go to shariawiz.com, create an account, answer the questions. It would automatically cancel, revoke the previous will.
جزاك الله خير.
No problem.
Most of our working people, I understand estate planning, but if we have a bank account with a joint right of ownership, I die, my wife becomes the owner.
Well, that's not Sharia compliant.
No.
That's fine, but it's not
But
Sharia compliant.
Those still are subject to estate?
If it's over that amount of money.
Okay, I got it.
I mean, if you're that rich. Now, you raised a particular issue. There's one thing that is we're working on raising awareness in the community. I just did a lecture about what's called special needs trust. We have disabled children. We have autistic children. So these children, if we leave them money when we die, they're going to receive their inheritance, and that would be considered their asset. Therefore, they will not qualify for public benefits. They won't get SSI, they're not going to get Medicaid, they're not going to get Section 8. So what we do is we create a special needs trust for this child. When you pass away, that inheritance goes into the special needs trust. The special needs trust is basically a supplemental income to help the disabled child. It's not the child's assets. So therefore, you still qualify for all government benefits, and now you secured your child with this extra money to take care of him. Supplemental needs trust or special needs trust.
If I want to give to my one of my kids more share, I can do that
No,
than the other.
you can't do that. You can do in your lifetime, give them something. You can create a trust specifically for a daughter or a son that's extra in your lifetime. But when you pass away, it has to go according to the rules. Now, there's the basic school of thought on this is that the other heirs have to agree. So let's say I want my sister to take equal to me. The father says, I want them to take equal. When you die, when the father dies, the children have to consent and agree to reduce the male share for the female share. So that approval has to take place after you die.
So in my life right now,
You could do whatever you want.
I can do, if I want to do welfare something in my life from my
But it's a gift. So you have to change and give up absolute possession and control and use of that property to your daughter, like opening a bank account and putting money in her name, buying a piece of property and giving it to her. That is a gift in your lifetime. That's not subject to inheritance rules.
If I want to make something welfare for the people, make a work, I can, what is there any restriction, anything?
No. A lot of people can create a family waqf that can be hybrid, meaning I'm creating this family waqf, half of it goes to my children, half of it goes to charity.
Right.
Or 80% go to my children, 20% go to charity. Because of the waqf, there are no restrictions on giving a daughter more than a son, or a son more than a daughter, or not including a son, because in the end, this is something done in your lifetime. So it is not inheritance. There was people who used the family waqf in history. They used it to help their daughters, help their wives,
Yeah.
and some of them used it to also abuse their daughters and wives and exclude them from inheritance. So it depends on the niyyah, and it depends on what you're doing. If your niyyah is to do a moral, equitable, fair thing, you could do whatever you want.
Okay, thank you.
And we can help you create that trust if you wish.
Assalamu alaikum.
Wa alaikum assalam.
Actually, I have two questions. One, if I create a trust in New Jersey and I move to another state or live there, should I recreate one or should I
No,
create?
generally you're going to be fine, but trusts and estate plans are a work in progress. You create them today, in 5 years something changes, you have to update and amend. So if you create a trust in New Jersey and you move, New Jersey is what we call an equitable distribution state. If you move to Texas or you move to California, they are community property states. So their laws are totally different. So then you can, what we call, restate and amend your trust, but it's not doing it all over again.
Okay, another question. If I have a property here in New Jersey and I live in New Jersey and I have another property in other states.
And that's why you have a trust, because if you don't have a trust, you have to open court both in New Jersey and court in where there is. But if you have a trust, the trust owns everything, no court, no issues.
Thank you. Jazakallah khair.
No problem.
So piggyback, I have two questions also. Piggybacking off of a comment that was asked earlier, or a question. So if in a brokerage account or a bank account you listed beneficiaries, the will would supersede whatever is listed
No.
in the bank, or no?
No. When you die in New Jersey, your assets are distributed two ways. According to what you say in your will, or according to operation of law. And by operation of law, what do we say? If you have an insurance policy and you put your cousin as your beneficiary, doesn't matter what your will says, that money's going to your cousin right away. If you have a retirement account and you put the beneficiary to be just your spouse, it's going to your spouse. Doesn't matter what you say in your trust or in your will. So if you have pre-designated beneficiaries in insurance policies, in retirement accounts, in bank accounts, it's going to go to the person that is already designated. The will only addresses anything that does not have designated. From an Islamic law perspective, that's why the effort is to change those designated beneficiaries, either making them the estate or updating and adding your children and the inheritance percentages in that designated beneficiary form.
Thank you. The second question that I had, so you just mentioned a minute ago, like if you sell a property, you would make an amendment. So if somebody's constantly acquiring or disposing of assets and a will's already created, how frequently do you have to make these amendments?
You don't make any changes because the will does not address any specific property. The Islamic will basically says, when I pass away, executor, gather everything that's in my name, distribute it according to the Sharia. So it doesn't matter. You can buy, sell 100 times. In the same thing for the trust. The trust, when you buy, sell, you're going to start buying and selling in the name of the trust. So let's say you create a trust today and we transfer your first property. Next month, you found another property, you want to buy it. You would buy it in the name of the trust, not in your individual name. So this way, it just continues. But if you bought it in your individual name, it's a very simple transfer that you're going to put in the trust.
Thank you.
You're welcome.
Was there a question from the sisters side? Sisters, do we have any questions from that side? They are? Okay, I'll... okay, does somebody want me to roll the mic over or put it in the chat? Anybody want the mic?
We should do another webinar about special needs trusts. We should advertise and find out people in our community that have any disabled or autistic children so that we can warn them and try to set something up to help them. We did that for the Islamic Center in Princeton.
السلام عليكم ورحمة الله وبركاته.
وعليكم السلام.
في واحدة من الأخوات بس هي مكسوفة تتكلم، حدا بتحكي عربي.
بحكي عربي عادي.
بتسأل إن في راجل كبير وعلى حياته عايز يدي واحد من أولاده أكتر من التانيين وهو من فلوسه وهو عايش. على إن اللي هو عايز يديله فلوس أكتر من أولاده دوت عنده حالة معينة وظروف خاصة زي ذوي الحاجات وكده، بس ولاده التانيين بيقولوا للأب كده حرام عليك وإنت ما تعملش كده، بس هو في حياته.
بحياته لا يوجد أي شروط تمنع أن يعطي هدية وزيادة لابنه في حياته عادي، ما في إشكالية. ولكن في إشكالية واحدة، إنه إذا هو ذو احتياجات خاصة قد يكون أفضل إنه نعمل له وقف خاص علشان الهدية لا تكون ملك لهذا الولد، إنما ملك للوقف، والمنفعة منه لمصلحة الولد عشان يستطيع أن يأخذ البنفيتس الحكومية. يعني لو هو على ميديكيد أو على SSI، إذا اديناه فلوس سيكون غير مؤهل لهذه الخدمات الحكومية. ولكن لو وضعنا هاي الفلوس ركناها بوقف وخليها تكسب فلوس مستقبلا، يكون أفضل له.
وهذا هو الوقف للسبيشال نيدز.
Special needs.
جزاك الله خيرا.
Yeah. Because nobody in our community knows about this, and people are losing benefits and not helping. And our community is now becoming second, third generation. We never thought of these things. So right now you have a child that is autistic and you pass away. He's an adult now, not a young kid, but he can't self-support. Who are you going to put the burden on? Your uncle? Your third cousin? What do? So by us setting up financial security, we're going to make it easier even for a family member to help, as opposed to putting the financial burden on that family member. You know, that family member can be the trustee of the trust to find suitable housing for that child. He's no longer a child, he's an adult. And we got to go through guardianship proceedings to get appointed because he's disabled. And he's technically a minor. Yes. No. You have to change that beneficiary form. Not in your will, not in your trust. You got to go to the administrator of your retirement account and tell him exactly. So you update the beneficiary. Now there's two schools of thought on the retirement. هناك من يقول إنه التقاعد يعتبر ميراث، ومن يقول إنه الريتايرمنت لا يعتبر ميراث. ففي القوانين الأحوال الشخصية الموجودة بمصر السعودية وما شابه، التقاعد يذهب مباشرة للزوجة والأولاد، ليس ميراث. But others consider it mirath and has to be distributed according to the...
I guess I'll ask a question. Is there any conflict between the rules of the Sharia in terms of inheritance and what the courts in New Jersey will allow as a will?
Yes, and I should have mentioned that from the beginning. Generally, in the United States, you as the testator, the person who is writing his will, you could do whatever the hell you want. Disinherit your children. Give all of your money to a cat or give it to your dog. You can disinherit everyone except one person. Can't disinherit your wife. No children, no parents. Give it to the dog. But you can't disinherit your wife. Yeah, so now for purposes of that, the conflict is very simple. In an Islamic will, you're leaving your wife 1/8 if you have children. Under New Jersey law, she has the right of what's called elective share. And the elective share is up to 1/3 of the estate. So she could contest the will, even though the will is valid and will apply, but the judge will just adjust the percentages from 1/8 to 1/3. But when we do Islamic wills and Islamic trusts, we have a waiver of elective share that is mutual. Husband waives his right to his elective share, and she waives her right to an elective share. And this way, it stays within. But there's a lot of husbands that you know, they don't want to tell their wives about this, so they don't get the signature, and they roll the dice and say, inshallah, she's not going to contest. No, you can't. No, disinheritance is haram. Haram, big time haram. You can give up to 1/3. Only with consent, and the consent has to take place after you die. No, in your life, if you give it during your life, not when you die. I'm giving you this computer now. No problem. I'm giving you this computer and I die. Problem.
One last question, and it's a general. Given your knowledge of the laws of inheritance, we hear a lot that Islam actually wronged the woman. What is your answer to this?
Very simple. Like we talked about the Islam as a methodology that produces knowledge. الإشكالية is that most of the time when people critique Islam, specifically on gender, they pick and choose and don't see the totality of the picture. When you look at Western culture, what Umar ibn al-Khattab did in the 7th century, establishing that a wife acquires legal and equitable claim in assets acquired during the marriage because of her contributions, was not the law in New Jersey until the 1950s. So when you see where we were, but people don't see the big picture. So in the big picture, pull any fiqh book. There's fasl nafaqat al-aqarib. This doesn't exist in the US. Nafaqat al-aqarib means me as a daughter can sue my dad even if I am over 18 for support. It means I can sue my brother for support. My mother can sue me for support. Nafaqat al-aqarib, you're responsible. So when you look at the totality, when you lived in a Muslim community, a Muslim society, when you look at the gender-specific financial obligations, it makes sense. So think about مثل حظ الذكر أنثيين. Now, the son takes double of the share. From that double of the share, he's responsible for the support of all the females that are in his family. He's responsible for the support of his mother, his father, his children, and his wife, and his aunt or whatever. He has absolute substantial financial obligations to all the females in his family. And he has to pay mahar, and he has to do all this stuff. When the wife takes her half, that's her separate property. She has no obligation to support her parents, no obligation to support her kids, no obligation to support her siblings. It's totally net, free. She gets net income, you're getting gross income, and Uncle Sam's gonna take half. So that leveling of the playing field, people forget. So that's why the system is the way it is. But today, we lost the extended family. We live in the United States. Brothers are not doing what they're supposed to do for their sisters. So it becomes problematic. Doesn't mean that we have to change the law or we're not adjusting the Quran. We're taking specific circumstances in our lifetime and we can make adjustments in our lifetime to address that particular issue. Maybe you have a daughter that's not married and she's in her late 30s and her 40s, has difficulty making ends meet. What do? The Quran and the Sharia is your responsibility to protect her and take care of her. That doesn't mean you change the inheritance rules. No, you plan. You plan and get a house in her name. You plan and help her. You put a waqf ahli to support her. So these are the things that you can do to take into account. But to say it's not equitable is not fair and it's not accurate because you're taking it out of a system. It's the same thing when we talk about Islamic finance. Islamic finance, even though I like and support Islamic finance, no riba and all that, the Islamic finance companies now are much more like Western finance. And it's better than conventional finance, but they're really losing the underlying moral economy. Because the purpose of the moral economy in Islam is that you look at the moral economy, it's not just riba and gharar. It's also zakat. It's also the inheritance law. It's also that our scholars had said that you have limitations on profit on many things. It doesn't include no limited liability corporations. The moral economy was to help everybody and level the playing field. Currently, it's just rich people who are just investing in the stock market and it's Sharia compliant and they're making money, but that's not trickling down to make an equitable, just economy for everyone. So this is what's happening, that Islam is being practiced outside of its comprehensive way of life, and it just complicates things. Same thing about polygamy. People also they don't understand polygamy. Western feminists just take this position that, this is not correct. I have one wife, I don't want any more. I'm happy with one, and I don't even know how people marry two wives. But you don't see the moral underlining of a second wife or a third wife. So what happens is that in Western culture, engaging in sexual relations outside of marriage is the norm. It doesn't matter. But if you're a Muslim woman who is a divorcee, you're older, you don't have the ability to have companionship outside of marriage because it violates your moral strictures. So why can't you see that as also providing an avenue for women who need to be compliant with their religious strictures and their morality? So it's just constantly, the critique of Western feminism is always disjointed and picking and little pieces. I had an argument when I started Sharia Wiz. This cost a fortune, and it's bleeding me still every month. But I believe in building this project, making it easier for Muslims. When I picked the name Sharia Wiz, all of the marketing companies that I hired wanted me to change the name. Because Sharia, it's ISIS, it's Qaeda, they're crazy. Sharia has all these negativities, cutting hands, killing people. And I said, I'm not going to change it. I'm not going to allow the Islamophobes to define what Sharia is to us. Because the Sharia is not about cutting hands, and it's not about stoning. Sharia is a moral system. And I constantly hold these Western feminists accountable, because when you dig deeper in the Sharia, you find things that most Muslims don't even know. Do you know in the United States, up until 1991, in Iowa, if a wife wanted to change her name to her maiden name, she needed the consent of her husband. You can't realize that Muslim women up until the 1930s, 1940s had more rights under Islamic family law than anywhere in the West. So that doesn't mean we have the raw material, we have a tradition that we can build on. We're not supposed to cancel 1,300 years of a tradition and adopt a Western tradition wholesale. We can work within our tradition. And we are working within our tradition in Sharia Wiz, and you heard the solutions we have for Muslim women. Why do I have to say Islam is not equitable to women when I have all these opportunities to do this? So if there's anything that comes out of our conversation today, is the Sharia is dynamic in a living tradition. And it's constantly going to evolve and adjust with the times. That's what makes the Sharia so sophisticated. And I hope that we all invest in our institutions so that we can continue this tradition.
We can change the event before the time?
Yes. Anytime before you kick the bucket. The will on Sharia Wiz is $199. The trust is $499, and the joint trust is $799. At our office, generally an individual Sharia compliant will be $1,200. If it's for a husband and wife, it will be $1,800. And for a single trust, it's $3,500. And for a joint trust, depending, ranges from $5,000 to $7,000. No problem. Yeah. You want me you verbally? Oh, I didn't know that we were live streaming. My office number is 201-462-9500. And my email is, if you're emailing me at Sharia Wiz, it'll be Abed, ABED, at shariawiz.com, SHARIAWIZ.com. My office email is AWAD at awadkoury.com, AWADKHOURY. And I have some flyers that we can yeah, we can share. And I'm always open. Anybody have any questions, just give me a call. Yallah, assalamu alaikum. Thank you.
Jazakallah khairan to Brother Abid. This is probably one of the most interesting and impressive presentations we've had in a very long time. Very much appreciate his time. So Jazakallah khairan on behalf of the community. And inshallah, we'll coordinate for future events, inshallah. Inshallah. Jazakallah khairan.
Hasbrook Heights in around Hackensack, next to Hackensack. These are all that you can do by yourself. If you feel that you want a lawyer, then you call me. But you can save a lot of money doing this, right? But sometimes you need a lawyer.
Just to compliment,
Yes.
I have a certified financial designation, CFP, and chartered financial.
Oh, so you know what I'm talking about.
But my professor never knew what you told me to believe.